Smith, you're going to represent this defendant?
I am, Your Honor.
Very well. There has been an amended complaint filed. Originally, as I understand it, there was a citation for reckless driving. The amended complaint, as I say, has been filed. Have you received a copy of that?
We have, Your Honor.
I know you probably just received it. Have you had a chance to read it?
We have had a chance to read it.
Would you like me to read any of that?
We would waive that reading today, Judge.
Very well. For the record, the amended complaint charges 2 counts of felony vehicular manslaughter, and counsel's indicated that he and the defendant have read that and are fully advised of the charges. All right, on felony charges, you cannot enter a plea of not guilty or guilty before me. That comes in the district court after a preliminary hearing now set for October 5th at 1:30 p.m. and you will receive notice here in just a moment with that date and hour in it. The file contains the amended criminal complaint, the motion in order to amend the complaint, and the probable cause affidavit. Bond has been set on these felony charges at $50,000. Counsel, were you probably just now saw that?
Correct, Your Honor.
Along with the complaint?
We did. We were going to address the court on that if you felt like it was appropriate.
You may do so.
Thank you. Well, Judge, I would just indicate to the court, as the court's aware, where this just was filed, usually my client would have had an opportunity to meet with pretrial. We've talked with pretrial. His family came here. They've acted responsibly. They've hired me. They made their appearance here today when obviously they weren't sure what was going to happen. They are longtime residents of California, but I am confident that he would make every appearance, especially where we've been retained and where he made this first appearance. Our hope was that the court might consider a pretrial release. I understand that pretrial has and can do that. He would have to check in here with them, but then he would reside with his parents where he has been residing back in California. My client has had a semester at junior college. He doesn't have any prior history other than an infraction or two out of his home state of California. So Judge, the only other thing that we were maybe going to propose, and I don't know if the court is up for this, but approximately if he paid the bond here, he would have to, or his parents would have to post approximately $5,900 with a bondsman. I would prefer if they could do a cash bond in that same amount. I think it has just as much holding power because they recognize they get that money back at the end of the case. That can also be used at that point in time for things like restitution, fines, costs, assuming there is some resolution of the case. I don't know if Your Honor will consider that, but I think we were considering at least asking for some type of pretrial release or maybe reduction in the bond if there has to be a surety, or potentially a cash bond, which I think would have the same holding power that a surety bond would have. So that's at least what we would propose, and we're happy to answer any questions you may have. Thank you.
I'll go to counsel here, but I did not see that the defendant's resident was in California. Honestly, the bond would be higher with an out-of-state resident.
Understand.
You may respond.
Your Honor, I think that out-of-state residence is an important consideration. I know that it was one of the considerations that led to Mr. Perea being cited over the weekend. The state would support, excuse me, the court having a bond that's fairly substantial in this case based on the nature of this crime involving the deaths of 2 individuals and the likelihood of conviction based on the defendant's own admissions to the speed that was involved in the collision and that sort of thing. So I think that based upon those factors, the bond should be high. In his favor, he's here today, but weighing that out, I think the bond should also be increased. This individual did show up for an arraignment on a reckless driving as well, which is something to consider, not an arraignment on vehicular manslaughter.
Your Honor, the only thing I would add to that is that when my client and his parents got in touch with me, they were notified that most likely this amendment was coming. So they actually came to court today recognizing that fact. And so I would indicate to the court is that I have a young man who has a very responsible family. They're here in the courtroom today. I have no doubt, based on my communications with them over the course of the weekend, that they will make every court appearance. I realize the court has to do things to make sure that is also satisfied. But I would indicate to the court that I think whether you were to leave the bond or whether you were to go lower on the bond, I think that it's quite not a fair argument to think that he showed up today just because he thought it was a reckless driving ticket. In fact, that's why the family's here. They recognize the serious nature of this and knew that this amendment was coming. Pretty much everybody's devastated by what happened here, and they recognize the gravity of the situation. Again, I think if you couple whatever the bond is going to be with a pretrial release, that way there's monitoring as well, not only through my office and my communication with my client and his responsible family, but also through pretrial. So we would recognize the importance of doing this, but I think if you did it that way, that would give everybody some confidence as well that pretrial is also involved. Thank you.
Anything further?
Nothing further, Judge.
On the defendant's side of the argument here on bond, I have an NCIC records check, and I'm showing no prior charges, no prior record, and that speaks well for the defendant. On the other side of the coin is that he is out of state, which previously I hadn't realized that, although it's right here on the face of the amended complaint, but I hadn't seen that because I just received it here about half an hour, about 15 minutes before I came in. And most important, as the prosecutors indicated, as Mr. Dewey's indicated, is that we have serious charges, 2 counts of felony vehicular manslaughter, where, according to the charge, 2 individuals died. And the penalties are such, they're more serious and quite serious. Weighing all of this, I'm going to leave the bond at $50,000 at this time. So that is my decision at this time.
Thank you, Your Honor.
And we will get the notice of the preliminary hearing to you in just a moment.
Great. Your Honor, might I inquire, I know the court's very efficient at this, but we're hoping that that order could be made available for this afternoon, and then we'll make arrangements for that bond. But I didn't know if you had any idea how long it might take us to receive that.
I've signed it,
Great.
and it'll go out with you with the bailiff.
Thank you, appreciate it.
Teresa Barker.